Hello, Colorado Realtors. I'm Scott Peterson, and thank you for joining me for another edition of Legal Bites. On today's episode, we are going to be talking about broker disclosure requirements in the state of Colorado. So if you remember in our last edition, I think it was episode 20, I spoke about seller disclosure requirements, often done through the seller property disclosure, but contractual requirements in the contract between the buyer and the seller that the seller is going to disclose latent defects to the buyer. So seller property disclosure requirements last week, and I'd encourage you to go back and have a look at that in conjunction with this Legal Bites episode. But today, broker disclosure requirements. Different requirement between brokers and sellers, and I want to point out a few things for you guys. First of all, some guidance on this issue comes from Commission Position Statement number 46, which I would encourage you guys to read, and that's the Commission's guidance on what broker disclosure requirements should be when it comes to a transaction. They set up this, or I should say they memorialize this test for adverse material facts, which is what the broker disclosure requirement is. It's adverse material facts about the property. So different than the latent defect test that a seller would analyze, adverse material facts is two different components. You look at materiality and you look at adversity. So the test in CP 46 that's articulated is, what's material? And materiality is what would a reasonable party want to know? What would a reasonable buyer want to know if they were buying this house? Is it a fact that a reasonable buyer would want to know? Or a reasonable seller would want to know in some situations as well? And if the answer to that is yes, then that fact is probably material. And then the second piece of that is it, if it is material, is it adverse? Is some aspect of this fact, does it have negative implications on the party that may be purchasing the property, as an example? So adverse material fact is the standard, and these are, for any disclosure requirements, whether it's a seller or a broker, all disclosure requirements are based on actual knowledge. So broker has to have actual knowledge of these facts in order to have an obligation to disclose. Similarly, a seller would have to have actual knowledge of a latent defect in order to have an obligation to disclose, because if you don't know, you can't disclose, and so you can't be held to that standard. And then CP 46 also talks about some exceptions to this adverse material fact analysis for property stigmatizations like murder, death, suicide, HIV death in a home, those kinds of things. Those are non-disclosures without your seller's consent for a broker because they are stigmatizations rather than facts. And so keep that in mind as you're analyzing. But I want to talk in terms then about license law, and what CP 46 really derives from is the license law, which is what governs any licensee in the state of Colorado, and certainly all of you good realtors. So let's think a little bit about how it applies in license law. So if you're acting as a transaction broker in a transaction, the one broker in the middle of a transaction, you're going to obviously maintain neutrality. In the commission's parlance, you're going to be a referee for that transaction, and you're treating both parties equally. In that regard, you would be disclosing, and this is pursuant to license law, obviously to the buyer you would be disclosing any adverse material facts related to the home or the listing to the buyer so that they had knowledge of that. And also to the seller, you would be disclosing any known adverse material facts related to the buyer. And those would primarily be in kind of financial conditions or ability to qualify for loans or those types of things. So you would have an obligation to disclose to the opposite party adverse material facts in both scenarios. Less frequently, obviously, most disclosure obligations have to do with the property itself, but so less frequently that you would have knowledge of and have a requirement to disclose maybe the financial qualifications of a buyer. But if you knew that and you were acting as a transaction broker, you would have an obligation to disclose that to the seller. That's an adverse material fact. So the next scenario would be when you're acting maybe as an agent for the buyer. What are your disclosure obligations? Well, if you're working as an agent for the buyer, you have a duty of a fiduciary duty to your buyer. And so you have the ultimate disclosure obligations. Really, anything that you know that may have any impact whatsoever on that buyer decision, it's the ultimate duty to disclose to that buyer. That's one of the sub-duties of fiduciary. And so that's very, very broad duty you would have to your buyer in the case that you were a buyer's agent and you had knowledge of a of a fact related to the property, even if it wasn't a latent defect or otherwise a disclosure obligation of the seller's agent to the buyer. I would argue that your duty to protect your buyer in terms of full disclosure of anything is even higher than any of those other scenarios because of the fiduciary obligation and relationship that you would have with your buyer in that case. If you're an agent for the buyer, your duty to the seller is not the same. Unfortunately, well, I don't mean to comment on unfortunately or fortunately, but you do not have the same obligation as a transaction broker would to treat the seller equally with regard to financial conditions and everything else. Brokers do have a duty not to perpetuate, or they have a duty to avoid misrepresentations, and so you couldn't necessarily help perpetuate some buyer that wasn't qualified and help them not disclose that to mislead or harm the other party in some manner. That's got all sorts of other implications, but not the same affirmative duty to disclose the financial condition to the seller in the case of you working as a buyer for the agent in that situation. And then the most common questions come around when you're working as an agent for a seller. What are your duties to the seller? Well, duties to the seller are the same. You're going to disclose to your seller, again under a fiduciary relationship, adverse material facts that are actually known by the broker about the property. Probably more limited because obviously in most cases your seller is going to know more about their property than you would as an agent. And you're not a home inspector, so I would caution a seller's agent from walking around a house and saying, oh, you've got a structural problem here, a crack in the wall there, or your roof maybe looks a little off. That's not what you're engaged to do. So I would never encourage a listing agent to go through and become a property inspector. That's not the subject of the relationship. But in the event that you had actual knowledge of those items, you would have to disclose it to your seller, and in the case that it was a latent defect, you would then have to disclose it to your seller, I should say, would have to disclose it to the buyer per the contract. The flip side of that, though, as a seller's agent, what do you have to disclose to the buyer? Well, that standard of adverse material fact in that case does extend to the buyer. So you do have, as a seller's agent, the obligation to make the buyer aware of any adverse material facts related to the property. That's a very different and inconsistent, in my opinion, disclosure obligation to what the seller's obligation is in terms of latent defects. And so consider that conflict between the seller's obligation to disclose to a buyer per the contract, the buy-sell contract that I discussed in the last Legal Bites section, or the last Legal Bites episode. Consider that conflict between that and what your disclosure obligation is, because adverse material facts about the property could, in your case, extend to activities occurring on adjacent properties. It's not latent defects on the property like the contract requires a seller to disclose. It could be much more expansive than that. So be mindful of that as you're considering what obligations you have to disclose to a buyer, even in your capacity as an agent for the seller. And that standard, again, is adverse material facts that are actually known by you, the broker. I consider CP46 to be a well-written position statement in the sense that it does set up some tests and gives you some guidance. So if you have more questions, I would encourage you to have a gander at CP46. It's 2 or 3 pages long, very readable, and gives some decent perspective on what you ought to be thinking about. And then, as always, Car Legal Hotline's available if you want some more specific guidance or feedback related to issues that you're having. So thank you again for joining me for another edition of Legal Bites. I always appreciate you tuning in, and hopefully you're finding these informative and helpful in your practice career. So thanks so much. We'll see you next time.